Well, good afternoon and welcome to today's seminar. Being a tribunal witness, frankly, can be the cause of dread. It's one of the things we can be asked to do by our employer that we're least well trained for, and yet it can be hugely important. Preparing to be a witness is often an isolated experience, carried out with limited support or appreciation of the process we're submitting ourselves to. So today we'll look at some ways of ensuring that you and your colleagues who appear as witnesses can understand better what makes a good witness, how you can deal with some challenges you may encounter, and how overall you can give a better account of yourself on the day. We'll begin with some basics. What happens in a tribunal hearing? Well, let's look firstly at who's in the room. There will be a judge or a panel made up of a judge and two members to decide the case. There'll be your advisor, whether it's someone from within your organisation presenting the case, or an external solicitor or counsel or a consultant. And there will be someone on the other side of the case, whether it's the party themselves or possibly they will have an advisor as well. And in Scotland at least, there should be no other witnesses who have still to give evidence. But there could be witnesses who have taken their turn already and want to stay behind and observe what happens next. Now, the approach in England and Wales is different in that respect, where witnesses are often allowed to sit in the hearing room at any time, and it's not unusual for witnesses to sit through the entire duration of a case. And finally, there may be other observers, whether it's family members, friends or colleagues, members of the public or even press, because as a rule, full hearings are open. Everyone will be in a certain place depending on who they are, so it will help you to get to know and begin visualising in advance how the room will be set out, who will be present when you go in and what some of their roles are. You should also know that there'll be a waiting room for people on your side of the case, and that's where you'll probably spend some time, and so you should locate it when you arrive. It's also important to consider what the tribunal will do in order to decide the case. It will rely on material from two main sources. It will consider documents, and they will be gathered together in an agreed file or bundle, as we tend to call it, and that will be something that everyone refers to as they go along. And secondly, it will hear the evidence of witnesses. And then it will decide what happened effectively, the most probable version of the facts. No two tribunal cases are different. No two tribunal cases are the same, sorry. In some, the facts will be well documented and they won't be in dispute. And in others, there are gaps in the documents or the parties disagree over many of the things that happened. And in the second type of case, the evidence of witnesses will be more important to fill in those gaps. So it will be important for you to know how you'll be asked to do that. Let's now look at what makes a good tribunal witness. A tribunal will always look for certain things in a witness, and we've listed some here. Firstly, credibility. Simply put, are you believable? Does your evidence make sense? Is what you're saying realistic? Is it internally consistent, or do you contradict yourself? And is it consistent with the evidence of others or the documents? Do you accept when you're faced with stronger evidence that there may have been alternative views or actions to yours, or even that you may be wrong about something? Do you recognise the limits of your own knowledge or expertise? All of these aspects, to a greater or lesser extent in each case, will go towards whether the tribunal will trust what you say. Next, reliability. Is your recollection good? Not necessarily perfect, because that's rare, but is it reasonable at least? And do you acknowledge when it's not? Or do you start to assume or speculate about things? And Craig will say a little bit more about the pitfalls of doing that. Clarity is important as well. Can you give clear and simple answers to questions? Can you cut out the waffle? Can you tell a short question from a more involved one and answer it accordingly? And can you explain technical or industry-specific terms succinctly to people who might be unfamiliar with them, which the tribunal may well be? And can you make it clear when you're talking about something from your direct experience or something that you learned secondhand, or if you're just giving a view on something? And finally, respect. Respect for the tribunal and the process itself, of course, but even respect for your opponent, who you may not like, but who is entitled to be there. So can you remain composed and professional and be seen to be helpful to the tribunal rather than getting into battles that you feel that you have to win? It helps Remember that the first thing you'll do when entering the tribunal room is take the oath or an equivalent to it. And that's to tell the truth, the whole truth, and nothing but the truth. And in many ways, it's as simple as that. And if in any doubt, that should be your fallback. And remember, it's not your job to win the case as such. Yes, you need to prepare, and you should raise any questions or concerns with your advisor before you give your evidence to put your mind at rest. But at the end of the day, it's your employer's decision to go ahead with the hearing, and it's your advisor's job to manage the case. So how can you best prepare for the experience? Well, firstly, you should familiarise yourself with the setting and the process. Learn the layout of the room. You may want to have someone give you a diagram of the hearing room if that helps, or just arrive early on the day, because you won't generally be allowed in the hearing room once it gets underway until your own turn comes. Find out who will be there from your advisor, whether it's a judge or a panel, who is representing the other side, if anyone, if there are any observers, and so on. And before the day comes, you may want to attend a hearing in another case as an observer to get a feel for how things work. But make sure you understand the tribunal day in terms of the starting and the finishing times, when the breaks are, who may be giving evidence before you, and who's coming after. Another thing you should do quite clearly is to review the documents, the tribunal bundle, as soon as you can. Tribunals usually order the parties to prepare it by a date before the hearing, so read it as soon as you get a copy. If any document causes you concern, raise it with your advisor, and if you think anything is missing, do the same. Someone should have met with you to discuss your evidence by now, so have they prepared even an informal statement or a summary of your evidence? If they have, then revise that, and again check that it's accurate. This should help you understand the issues you'll be asked about, but clarify that with your advisor if you're not sure. And make sure overall you understand why you're there. It may just be to describe a simple process you followed, but you may have to explain and justify some decisions that you took or situations where you exercised your judgment in a particular way. Can you do that? And get a sense of how long you'll be giving evidence, because being a witness can be as much a test of stamina as anything else. So be sure you're prepared for that and not distracted thinking about other commitments. Very importantly, raise any questions or concerns you have with your advisor as you're preparing, and certainly before you go in. Now, nearer the time, or even when the hearing is underway, don't be afraid to ask for an update from your advisor on when you will be called, who may be questioning you, or what's their style. And that can apply both to the other side and sometimes the judge and members as well. And finally, a word on whether you should prepare or interact with other witnesses before the hearing. It may be unwise to do that. Revision is fine, but collaboration or coaching is absolutely not. There is always a risk that your own evidence is changed or supplemented by others. You may even be asked in the hearing whether you prepared with other witnesses or discussed your evidence with them, and generally it's usually best to be able to say no in answer to that question.
Thanks, Brian. So the preparation's now done and you're in the tribunal hearing room. The judge takes you through your oath or your affirmation, and you're now just about to start giving your evidence. So how does it work? Well, the general running order is that we would start off with what we call the examination in chief, which is then followed by cross-examination and then re-examination. So to explain those, examination in chief is where your own advisor will lead you through your evidence by asking you a series of open questions to allow you to present your evidence to the tribunal. Cross-examination is probably the bit that most witnesses will be apprehensive about going into the proceedings. And this is where the other side gets the opportunity to challenge the evidence that you've given. The representative, or if unrepresented, the other party themselves will do the cross-examination, and the style of questioning is likely to be quite different to that used in evidence in chief, with a focus on more closed questions. We'll talk a wee bit more about cross-examination in a few slides' time. Re-examination, this is the opportunity for your own advisor to step back in after cross-examination and to ask you any further questions. Usually the purpose of those questions will be to address anything that's perhaps become problematic or anything that's become muddled or confused through the process of cross-examination. Now, the last box we've got on the slide there is tribunal. We've put that last in the order, but in reality, it's quite judge dependent. Certain judges will intervene as and when things come up throughout your evidence to clarify points. Others will save their questions up until the end of that particular part in the process. Panel members, if panel members are sitting, will also have an opportunity to ask questions. But really, the point to remember, I suppose, is that you shouldn't be put off or alarmed, regardless of which approach the judge takes on the day. The judge's job at the end of the day is to make sure that they fully understand all of the evidence that's been given, and they'll each have their own way of approaching that during the process. So some tips when it comes to giving your evidence. One of the sort of key themes, I suppose, that's running through the session today is, trusting your advisor and preparing. So trust your advisor to know what to ask you, to know how much to ask for, and to know what not to ask about as well. Listen carefully to the questions that are put to you. Clarify if you're unsure about anything that you're being asked, and then focus on answering the question. And one thing that I always say to witnesses at the preparation stage is that, you shouldn't feel the need to continue speaking to fill any periods of silence. The nature of the process means that there will be frequent pauses or gaps after you've finished giving your answers, either to let the judge catch up on his notes, or perhaps whilst the representatives consider their next question. So the message, I suppose, is if you've finished giving your answer and you've said everything that you wanted to say, then just stop. And if more information is required, then just leave it to the representative or perhaps the judge to step in and ask you for more information. If you're giving long answers, try and signpost it and structure it in a way that the tribunal is going to be able to understand and digest. And the points that Brian was making earlier on in terms of clarity are also going to be important too. Pace is important. Calm and measured is probably the best approach. Bear in mind that the judge will be taking notes, and again, each judge is going to be different in terms of how they record the evidence. Some will be word for word, others will take a more shorthand approach. The judge will probably explain that to you at the start of your evidence, and if you're going too fast, the judge will be sure to let you know about it. Similarly, if you're not speaking loudly enough, the judge will be quick to tell you to speak up. Documents. Brian's mentioned the bundle. The bundle is really important in tribunal hearings. If a document in the bundle is going to be helpful to your evidence, then say so. This is where your preparation really starts to come into play, because if you're familiar with the documentary evidence in the bundle, then you'll know what you can refer to and when it becomes relevant during your evidence. And final thing to say, I suppose, in terms of tips, is that don't rush. If you feel that you need to take a moment, then do that. The words that you use are important, and you can find yourself getting into a bit of a hole, or perhaps creating pressure for yourself if you say something in a way that you didn't intend. So best just to stay calm and measured and take your time if you need it. So moving on, weaknesses in evidence. It's going to be really rare that there'll be a perfect case that goes to tribunal. There may well be potential problems in your own involvement, and it's the nature of tribunal hearings that these are going to be analysed. So what do you do about weaknesses in your evidence? Well, again, preparation, discuss with your advisor any concerns that you've got, and by doing that, you can start to make a bit of a plan in terms of how you might approach it at the tribunal. Your advisor can also help you to understand if the issue is going to be a major one, or if it's perhaps going to be more minor than you anticipated in terms of the overall case. And reasonableness, it's important to keep in mind that many of the legal tests that are relied upon in the tribunal involve doing what's reasonable rather than what's perfect, and it's effectively an objective test. So really there's often more than one acceptable course of action, So sometimes you can get a bit worried about that when it's perhaps not as big an issue as you had anticipated. Be prepared to meet criticism head on. Often the most transparent way to deal with weaknesses in your evidence is just to be upfront about it. So when you're discussing how you might tackle these issues with your advisor, you can agree whether it's better to be upfront about it when you're giving your evidence, or whether you should just wait to be asked about it. Again, it's a case-by-case thing, depending on the wider circumstances. And if we move on to some memory issues, what if you don't recall something when you're asked about it? Well, it's human nature that memories are going to fade over time. This is recognised by the tribunals and judges, particularly in cases where a significant period of time may have gone by since the material times in the hearing itself. It can often be anywhere between 6 months to a year, and in some cases perhaps even longer. So what can you do to try and help? Well, the first thing is revision. Hopefully that's going to help you with your recall when you get into the tribunal hearing, and it's another reason to make sure that you spend enough time preparing properly. It also helps to familiarise yourself with the relevant documents that are in the bundle, which you can of course refer to in your evidence. But I think it's important just to say at this point that you generally won't be permitted to take any notes, witness statements, or other memory aids into the tribunal with you. It's just the bundle of documents which will be on the witness table when you go in, so you don't need to bring anything with you. Of course, if you want to try to refresh by looking at witness statements or notes in the hearing room, that's fine, but you won't be allowed to take those into the tribunal with you. If you forget something, don't rush to fill in the gaps with assumptions. You can get yourself into a bit of difficulty by doing that, and often one assumption can lead to another, so best avoided. Credibility. So when it comes to lapses in memory, some are going to appear more credible than others. If you can't remember something, then it's helpful if you can at least try to explain why you might have forgotten something. If you can offer a reasonable explanation, i.e. the passage of time has been so long, or you've been doing so many similar things that things become confused, then that sounds simply better by saying, you know, I just can't remember. So the dreaded cross-examination, probably the toughest part of being a tribunal witness is cross-examination by the other side. This is their opportunity to try to pick holes in your evidence, as well as your overall credibility. We've got some things that they might try on the slides here that we're just going to run through. So the first one is that you may be asked artificially restricted or closed questions. And the typical example of that is the other side trying to restrict you to giving a yes or no answer, when really it's not that simple, or the wider context is really important. So you should feel free to answer these questions to give the answer that the other side are looking for. But if it's the case that the wider context is important, or it's just not that simple, then you should try to get that across. And whilst the other side may be trying to restrict you to simply saying yes or no, the reality is that a judge in a tribunal hearing is unlikely to stop you from saying something as a follow-up to that if it's relevant to proceedings. You could also be asked general or vague questions, with the other side later trying to apply your answer to specifics. And again, you just need to be alert to that and be firm to it if it's been stretched too far. One of the big ones, I suppose, is that your competence, integrity, or judgment may be questioned. You may be called a liar. It may be put to you that you're not telling the truth. It could also be put to you that, or you could also be asked to criticise someone else in order for you to appear to be right yourself. Now, the other side may try to do this because any admission that you make could help their case, or it might just be an attempt to try to unsettle you. And the mental aspect of giving evidence is so important. it's a pressurised, unnatural environment, and it's possible that the other side will try to use cross-examination tactics to try to unsettle you, or perhaps to try to provoke a reaction. Again, if you can stay calm and measured, then that goes some way to helping with those. You could also be asked to give a view on something that falls outside of your area of expertise or your experience. This is probably something that you should resist. And it's fine to say to the tribunal, or to answer a question by saying that you just don't know, because it's outside of your remit or your knowledge. You could also be asked if something is possible, and then have it implied that you agreed that that's likely, or it was actually what happened. Again, you just need to be alert to this happening, and if it does, don't be afraid to point it out. And with a lot of these things, it sort of comes back to preparation in a sense, because it's about anticipating where the potential lines of attack are going to come from and paying attention to that when you're being asked questions. Preparation and trusting your advisor to help you with those are important things. And remember also that after cross-examination is finished, if something or some areas of your evidence have become confused, then you need to trust your advisor to step in and re-examination and to know what to try to put right at that point. So to quickly sum up on where we've got to, I suppose, as Brian said earlier, it's not your job as a witness to win the case, but you can certainly do a lot to try to not lose it, and preparation is going to be a key to that. One of the other key themes that's ran through the session this morning is about trusting your advisor and working together to make sure that you're properly prepared. And that is so important. If you've got any questions, or if you've got any doubts at all about the process or your evidence, you need to be upfront about that and make sure that you and your advisor are on the same page before you go in. And then the overall benefit box there, this is the sort of silver lining, I suppose. It's probably going to be unlikely that you're going to enjoy the experience of giving evidence at the tribunal, but the feedback that we tend to get from clients who have been witnesses in tribunal hearings is that it's actually so beneficial in terms of experience and in the way that you work going forward and how you help others who may be in a similar situation in the future. It lets you see how these sort of day-to-day HR issues can materialise and develop into legal processes, and it lets you see how it all unfolds as well. So I don't have anything else to say on that, but before we move to questions, Brian, do you have anything else that you want to add?
No, Craig, thanks very much for that. We do have time for perhaps one or two questions. So we've got one here that reads, will people outside of the hearing get to see what I said in the tribunal? Now, one of the ways that might happen, we touched on, which was that if anyone attended the hearing as an observer, which might just be a member of the public who took notes and who decided to circulate those, or more likely perhaps someone like a journalist attending the hearing, then if that person did, quotes from your evidence or a summary of your evidence could well be reported more widely, and that would be there for the public to see, depending on the readership. That's fairly rare, though, for journalists to be in employment tribunal hearings nowadays, and I would imagine that if it's that type of case that you're giving evidence in, your employer will usually have a sense of that early on, and there will be a discussion about the likelihood of that. So it's a possibility, but it doesn't happen too frequently. But another way in which your evidence might come to the public's attention is that if the tribunal gives a judgment at the end of the case in writing, then it's probably going to mention your name and record at least some of your evidence in that judgment. And sometimes tribunals will even make comments about how the witnesses came across to them, how they found the witnesses. And nowadays, all judgments are put online and viewable to the general public. So it's possible that your evidence as summarised or the impressions of the tribunal about you as found in the judgment would be accessible that way. So that's perhaps an extra incentive to prepare well and give your best account of yourself. And I see we have another question here. What if I'm asked to be a witness for the other side of the case? Craig, do you want to deal with
Yeah,
that one?
sure. So if it's simply a request from the other side, then ultimately it's your choice whether to say yes or no. Now, your answer is probably going to depend on the nature of the evidence that they want you to give and the overall circumstances. Is it going to be a case of just going along and saying something straightforward, uncontroversial, and factual? Or are you going to be asked to go further than that and possibly say something that could be unhelpful or undermine your own employer's case? I suppose you probably want to discuss it with your employer as well first to see what their view is. You've obviously got a relationship, an important relationship that you need to look after there. And if you find that you're coming to a difference in opinion, then you need to try to find an appropriate way to resolve that. But at the very least, you should be letting your employer know that you're a person that the other side thinks is important in terms of the evidence that you can give to the tribunal. The other thing to mention, I suppose, is that if you say no, or if any party is unsure about whether a witness is going to attend voluntarily, then it's possible to make an application to the tribunal for a witness order. It's not just a case of asking for an order and it being granted. The party needs to justify, why that person should be ordered to go to the tribunal. If you are served with a witness order, then you lose the choice. You've got to go. Potential if you don't go is that there could be a fine. Obviously, if you've got a good reason in terms of illness or something else which is reasonable in the circumstances, then that could be avoided. But generally speaking, if you are issued with a witness order, then you need to go along. I think that's probably all I had to say about that.
Thanks very much, Craig. Well, just conscious of time, we'll bring matters to a close. So thank you again for joining our webinar today. We hope it was of interest to you. We at Brodie's provide more extensive training to organisations who have people who will be tribunal witnesses, and we cover many of the aspects that we've touched on today in more depth, using real life examples from our collective experience as a team and techniques such as role play. So if you want to find out more about that, then please do get in touch with us. So once more, thank you for joining the webinar and have a good afternoon.
Thanks.